Welcome back to Fired Up. D. Scott Crook is the Utah employment lawyer. He's consistently listed in Rocky Mountain Super Lawyers and Best Lawyers in America. He is the managing partner of Crook Legal Group. Fired Up focuses on questions that he frequently receives from his professional and executive clients regarding severance, employee stock option agreements, executive employment contracts, and more. Scott is only licensed to practice law in Utah and Idaho. He is not giving specific legal advice. This shouldn't be construed as legal advice for your problem. If you need specific legal advice, please go to an attorney. Scott is an attorney. We'll leave it at that. So, Dad, I've got some interesting questions for you today.
That's great. I'm happy to hear them.
Yeah.
Let's see if you can stump me.
I kind of searched LinkedIn. I looked through Reddit. Reddit has a wealth of interesting stuff. And today, I'm going to focus on sign-on bonuses. You know, this wasn't necessarily what executives were doing, but during the pandemic, Amazon was offering, gigantic signing bonuses for people who stayed for a certain length of time. And one of my first jobs, I had a relocation bonus, which was kind of like a signing bonus. But anyway, so I've got a couple of questions about signing bonuses.
Well, before you get to the questions, though, I just want to. It's actually not unusual for an executive level employee to get a sign-on bonus.
Oh no, sorry, bonus. That's not what I was saying. What I was saying is executives weren't necessarily going to Amazon for the warehouse signing bonuses.
Yeah.
But yes, I know. I know that's probably a pretty common thing for an executive, especially a more senior one who's getting recruited to go to a specific place. So I found a couple of different questions that I found on Reddit. So I'm going to read this first scenario to you, and then I have a couple of follow-up questions. So this person says, I received a sign-on bonus when I started at this company, and in the offer letter, all it says is, if you voluntarily leave the company within 24 months of receipt, the full amount of the bonuses must be repaid. It doesn't say when or how or any other details. I'm leaving the company this week, and they are telling me it has to be paid back by my last day, even after I explain that I can't pay it by then due to moving expenses for my new job, breaking my current apartment lease, etc. I'm not really sure what to do since my offer letter does not say I absolutely have to pay them back by my last day. I told HR and payroll I would pay them back shortly after I start my new job. Any advice would be greatly appreciated. So, first, can you just answer that question?
Well, it's interesting because at least in Utah, again, I'm only talking about Utah,
And actually, this question was asked by someone in Utah.
Okay.
By coincidence.
Well, that's interesting. So, the offer letter itself obviously had ambiguity, and if that's the only thing that the offer letter actually said, then it obviously it's in the employer's interest that you pay it back immediately, and you pay it back before you leave. But there's nothing an employer can do to force you to do that. In other words, they can't say, "Oh, I'm sorry, you can't leave," because we fought a civil war about slavery, and you can't force somebody to work for you. And actually, in Utah, you couldn't even withhold the money from the last paycheck unless the employee has signed an agreement that says you can withhold the last paycheck if you owe, if you owe the signing bonus back. So the only real option to the employer is to sue the employee after they leave to get the money back. Obviously, this employee is actually saying, "Well, I'm going to pay him back, but I can't do it on by the
Right.
time I leave." And so, um, unless there's something, there could be some provision in there that says, "Well, we get to um, charge you interest or whatever." I seriously doubt it if it doesn't say how it's supposed to be paid back. That's actually quite a sort of a draconian clawback because most of the time, um, on signing bonuses, they'll prorate it. They'll say like, okay, you have to work here for at least 24 months, or you have to give back the signing bonus, but we'll prorate it for every month of work you've done. That's sort of usual, but it's not to say that they can't do what they're doing. So
Right. So, but does this person so but they could but the employer, since the person signed the offer letter, the employer could sue them and win to get the money
yes,
back.
yes, um, they could. And um, yeah, and then it's really up to the employer whether they want to do that. But yeah, because it was given on a condition, you failed to fill the condition. It's a contract, and so an employer could sue and win.
Okay. So are there any laws about like are there any laws that dictate like if there is ambiguity here? It sounds like you're saying, well, I'll just ask you the question, but I think I know the answer. Are there any laws in a situation where there's ambiguity like this that say when something has to be paid back like
No,
this?
no. Um, what a when there's no payback provision in like if there's no specific contract language that says, well, you have to pay it back within X days, the law is going to um a judge is going to imply a reasonable um time period for that. And so if someone were to go in, for instance, if the employer were to go in and say, "Oh, well, he had to pay it back," this employee, assuming it was a man, he had to pay back the employer before he left, a judge would say, uh, "I don't. That's not what it says." And so I would say, most judges would, infer a reasonable time for
Okay.
payback. So
That makes sense. So, how would you recommend an employee navigate a situation like this if they let's say that they don't want to pay it back right away and the company's expecting them to?
well, it's a part of negotiation. I think the best thing to do is I mean, it sounds to me like what this employee did in this particular question was actually quite reasonable. I mean, he says to the employer, "Hey, look, you know, I know I got to pay you back the signing bonus. It's unrealistic. When do I need to do that?" They say, "Well, you have to pay it back by the time you leave." Employer says, the employee says, "Well, I really can't do that." Um, I just say continue to have that kind of a conversation. That's what I would recommend anytime. Of course, I represent a lot of employers, and if an employer were to come to me and say, "Hey, I want to put something like this in uh, in place," I would recommend they do a lot differently than they did. I mean, I would
Yeah.
say that you would negotiate all of that, and that would be included in the offer letter itself. And but to the extent that it's not, then I think it's just a matter of having a conversation with the employer and being reasonable. And sometimes employers get upset in some circumstances, and then maybe they will act unreasonably, but most of the time they'll be reasonable.
Okay. Okay, great. Let's move on to the next. So the next question I found on Reddit. So these are all a little bit similar. They're all a little bit different. So
Yeah.
this one says, so when I joined the company, I got a sign-on bonus with a don't leave before 2 years or pay it back wording. Now they're doing layoffs and I'm super nervous. Told an old boss of mine and they offered me a role at a good company, but I'm under the 2-year mark. Has anyone seen their company chase that bonus repayment? Or did your company let it go? Trying to see what companies actually do. So, first, if you could just answer that question, you have a lot of business clients where you actually represent the businesses. How important is it to businesses to, if someone does leave before the 2 years, how important is it to them to get that money back?
Well, I mean, it's hard to do a blanket. It really depends. Obviously, depending on the size of the bonus, too, that will impact a lot of things. So, if it's like a $1,500 bonus, that's real money to somebody, but you'll probably spend more than that in attorney's fees before you even file the complaint, right? So, a business may not chase it. On the other hand, particularly if people have a hard time getting employees, which is really what motivates a lot of these employee sign-on bonuses. I'm sorry. If it's a substantial amount, then they may want to pursue it, and they may want to pursue it aggressively. Now, I would say that for the most part, depending on the size of the sign-on bonus, employers are not going to vigorously chase them because it doesn't make a whole lot of sense.
It's not profitable.
Yeah. But I can't say that
Right.
for sure because there are some there are some substantial bonuses that get paid, and particularly among professionals where there's a shortage. I would say that like medical practices, like if they're providing a sign-on bonus to a doctor or to a nurse or something, they are probably likely to pursue it. Sign-on bonuses aren't really very frequent in law firms and that sort of thing, but I would anticipate if in a professional environment, they are probably more likely to pursue sign-on bonuses.
Okay. Now, this kind of begged another question. If a company lays you off before the 2 years is up, so if it's not the employee's choice to leave, can they take the money back?
Well, it all depends on what the language of the sign-on bonus says. Generally,
Right.
sign-on bonuses are the language they usually have is if you leave voluntarily or you leave or you're terminated for cause or something. Those are usually the provisions. In a layoff setting, that wouldn't be for cause, and so
right.
often it doesn't matter. Now it can be tricky because you can hear rumors of layoff and then you think, well, I'm pretty young here, I'm still under the sign-on obligation, I'm likely to be a guy that's laid off. I'll go find another job. Before I did that, I would go and talk to the employer and say, hey, I understand there are going to be layoffs. I'm fairly young here. I'm curious whether I'm subject to this, and if I went and found a job, would you require me to repay? Even though you haven't made the decision on the layoff, and give again, starting the conversation, I would say in that situation, they're unlikely to pursue you unless they really like you and they want you to stay and they want to lay off other people. They're likely to not ask for it back.
Okay, yeah. And that first question I asked you, the language that person shared was if you voluntarily leave the company. The second one doesn't specify that, but that makes sense. Okay, here's the last one. So this one says, I started a salaried job a little over a month ago, and during my onboarding, I was told I would get a sign-on bonus that would be broken up in payments starting with the first 30 days. I emailed HR after the 30 days to check if I will still be receiving my bonus on my upcoming paycheck and was told she checked with corporate and I would not be eligible for a bonus. She did not notify me of this at all until I asked her. I also had a signed agreement that had my signature, HR signature, and my supervisor's signature. I ended up asking my supervisor about it as I had forgot she had signed it too. Turns out she was not aware of any kind of agreement and that signature was written without her permission. I was able to contact my HR's boss and was told that it was a mistake. My supervisor told me she also talked to the HR's boss and nothing had come from it. They only acknowledged that they did not go about it the right way and will make sure this does not happen again. I don't even care about the bonus. I wasn't expecting it. It's not my problem that I was promised something with the signed agreement without them even verifying if it was applicable to me. My question is, what can I do going forward? I'm a little concerned about the signature forgery on my supervisor's behalf, but I do not believe she would have taken action against them at this time. So drama.
So I am very confused by everything in that scenario because I don't understand. First of all, he's saying he was in a meeting and
So,
found out that there would be a signing bonus.
so this person says that during onboarding, this person was told that they would get a sign-on bonus over time.
Yeah, so
And then
that's the
he emailed after the 30 days to see if he was still getting it. And apparently he had signed an agreement that said that he would get the bonus. Right? He says that they says he signed it, his supervisor signed it, the HR person signed it. But then he said that his supervisor ended up saying, I never actually signed that. And they just told him it was all a big mistake.
well, and I understood that as you described it for me, but what I don't understand is this. Okay, so this makes a difference in the analysis. So I'll just talk about this. If he was offered a job and he was not, as a condition of that employment, if the sign-on bonus was not offered to him before he ever signed, before he ever took the job, and if it did not include a sign-on bonus, that would make a difference. Okay, it sounds to me like when he was being trained, when he was going through his initial onboarding, that then they told him he would be eligible for a bonus and that it would be paid out over time. That's what it sounds like to me. Okay. So then he signed. After that happened, apparently, then this whole signature thing happened.
Right.
In that scenario, given that he wasn't promised sign-on bonus as a part of the negotiation of his job, he probably, under the scenario I've just described, he wouldn't have the right to a bonus because it sounded to me like they said, "Oh, you'd be eligible for it. This is how it'd be paid off and paid out." And even though there was some uh, signatures back and forth over that um, that is probably not enforceable. And that's simply because he didn't take the job thinking he was getting it. This was a benefit that was offered to him after he started. And then when they realized it was a mistake, they withheld it. In other words, he didn't keep working just because he was promised a bonus. This was just like an extra benefit. And if there was a mistake, he would likely not be entitled to it.
So,
Now,
well, the way that I understood it was that in this onboarding meeting, at least the way that I read it was and I guess it doesn't make too much sense to me, but that he was like given something to sign that said you're getting this bonus.
right.
Right. So if he was giving something in this meeting that says you're getting this bonus and it's signed by all three of them, then is there a problem if he doesn't get it?
Not
Besides the
necessarily.
obvious negative impact to morale.
Yeah, besides that, I mean, from a legal perspective, if there was a mistake, there was a mistake, and that doesn't bind him. The issue would be that doesn't bind the employer. It's just like if the employer said, well, we're going to make it. This happens in other benefit scenarios, and that is this. Well, we provide health insurance to you, right? The, well, we provide health insurance to all eligible employees. Then employee comes and they sign up for the health insurance, but health insurance has a different contract. This is a contract between the employer and the employee. The employee then fills out all the paperwork, and then they get a notice back. You're not an eligible employee,
Right.
so you don't get health insurance. This sounds similar to that. And in that circumstance, you don't have the right to get it, right? So the key distinction would be is if there was a promise before you started working and that you relied on that promise to work, and then they said, oh, never mind, even though we made that offer to you in the offer letter, and even though you've worked 5 days, you're not entitled to that sign-on bonus. You would have a right to claim that, because that would be a breach of the offer and acceptance. Now, if the scenario could also be different, if they said, oh, you're eligible for this, and he said, oh, well, I will only work if I actually get this. And they said, oh, you'll get it, and here's a signature, and then you signed, yeah, this is part of it, and then you worked another day or two or a week, and then they said, oh, never mind, because that became a condition of you continuing to work.
Okay.
So I don't know if that makes sense, but it does make a difference.
No, that does make sense, and that's interesting. I did not know that. So thank you, Mr. the Utah employment lawyer. You've taught me something new today.
Well, I'm happy to do it.
Good. All right. Thanks, everyone, for tuning in to Fire It Up. Please rate and review us. Subscribe if you're so inclined. And we'll talk to you next time.
Thanks.